Now I come to my second lecture, which is on some basic concepts of law and economics. Now I have to... So I deviate a little bit from the slides here because I want to first discuss with you one string of literature which might also be interesting for you and for the Indian situation. That is the debate in law and economic scholarship about rules versus standards, based on writings by, for instance, Richard Posner, one of the great names in law and economics, a pioneer, Stephen Shevell, also a great name, Tom Hewlen. You might know him from the book Cooter and Hewlen, you know, the law and economics book. I have to add myself, because I've also written on that, and Francesco Parisi. Now, what does that mean? Some of you are lawyers, and for you this might not be very new, but when we look at a legal norm, then this legal norm can either be very precise, a precise legal norm. You know exactly what it means. And we call such a legal norm a rule. Or the legal rule can be muddy, it can be imprecise, and then we call such a legal norm a standard. Now, for instance, to give you an example of a precise legal norm, in the German Constitution we have a rule according to which the President of the Republic has to be 40 years, at least 40 years, when he is elected. I think you might have a similar rule in the Indian Constitution, or does anyone know?
35.
35, okay. In Germany it's 40. Now this is a precise rule. So, for instance, if in India somebody would be elected who is 33, let's say, then you cannot say, well, he's only 33, but the rationale of that rule is that somebody has already some experience and some, has the character, the ripeness of a 35-year-old, and even though he is only 33 or she is only 33, he has already the ripeness of somebody who is already 50. You cannot do this. It's a clear, precise rules. You cannot ask questions or make arguments about this. This is a rule. Or another precise rule is the traffic light. If it's green, you can go. If it's red, you cannot go. That is also a precise norm. Or another precise norm, which we find, for instance, in the Russian law, a corporation law for stock-listed limited corporation in Russia, is that one of the directors in the board must be elected by the shareholders by a supermajority of 90%. That is also a precise rule. And the rationale of this rule is that, you have always a problem in stock-listed companies and big companies, that the board of directors and the managers put their money into their own pockets and at the expense of the minority shareholders. So this rule guarantees that there is at least one insider in the board who knows everything what's going on, who has the trust and who is trusted by the minority shareholders. Therefore, the supermajority of 90%. Such a rule does not exist in the United States, for instance, for a reason which I come back later. But then we have also norms which are not precise, which are vague. For instance, in tort law is the law which contains the rules according to which a tortfeasor must pay damage compensation to a victim. Right? Now, there is a rule in tort law almost of all countries which goes basically like this. If somebody negligently inflicts a damage to another person and damages his property or his life or his health or whatever, then he must pay damage compensation. So this is, with regard to the term negligence, not very precise. What is negligent? It is a very open-ended question. But on negligence, everything depends on negligence. And the courts have to decide in a particular case what negligence actually means. So this is a standard. Do you know, when I ask you of a standard in your own law, in your own legal system, a rule which is not precise but which is muddy?
Companies must, when they prepare financial statements, they must give a fair and true view of a company's financial position.
I have not fully understood this. Can you? So the financial company's financial position
Must reflect true and fair financial position of the company. So, for
If-
instance, if you think that you will incur a future loss, that should be accounted for in today's books as a contingency amount. And
Yes.
market losses should
I
also be
see.
captured.
Yes.
This is very vague because companies have the flexibility to either show future, either override future profits or
Yes.
undermine future losses.
But why is that a standard, an imprecise standard?
So I think it's difficult to account for all sorts of accounting entries. I mean, it's not easy to say if X, then Y is the amount that should be captured in a financial statement. I mean, these things are, companies are in so many sectors, it's very difficult to sort of have a firm body of rules which will.
So, do you mean by this that the rule does not exactly describe to the management or give exact instructions to the management as to why when, under which condition exactly he has to inform the public, but leave some discretion to the management? Is that?
Yes.
Okay, good, yes. That's a good example.
Medical negligence, that is also very imprecise.
Yeah.
It's not very, very clear.
Yeah, so,
And so the question is that who decides on such matters?
yeah, of course, and we will come to that. But first, it is important to understand that sometimes the law is very precise and sometimes the law is not precise at all. So one could say, so what? Why do we not have always precise laws? Why do we have imprecise laws? What is the rationale for having such imprecise norms which do not tell exactly neither the courts nor the people what they should do. Sometimes you have very vague formulas in the law which say, well, you should act in good faith when concluding a contract, for instance. And then again, it is open what exactly good faith means. Or you should, when making a contract, you should be fair. There should be fair dealing in a contract. What exactly is fairness? Again, this is somewhat unclear. Now, I want to illustrate you the relative merits of a rule and a standard by an example which is not very important. It's not a very important example, but it illustrates what I have in mind. It illustrates the relative merits. Now, in Europe and in Germany, it is the parents of a child give the child the name. I think that is the same here, right? The parents decide when they have a baby what name the baby will get, right? Okay. Now, when I give you the rule in my country, how it was 250 years back and how it is now. So 250 years back, we had the same rule. Parents should decide the name of the child. But they had to pick the name from a closed list which was part of the law. So the list had, let's say, 5,000 names, and they had to pick one of those names. They could not give any fancy name to the child which was not on the list. Today, the rule is different. The parent, so well, 250 years ago, when the parents would give the child any name, then they would go with the name to the registration officers at the birth register, and the registration officer would hear the name and then look it up in the list, whether it was in the list. If it was in the list, he would write this name into the birth register, right? Today, and if it was not on the list, he would not. He must choose another name, one which is on this list. And otherwise he would not register the child in the birth register. Today it's different. The rule is different. The parents can use any name, however, with two qualifications. First, the name has to reveal the sex of the child. Of that there are some exceptions. For instance, Mary is possible to give. You can name a boy Mary if he has also another male name. But there are many boys with the name Mary. That has cultural reasons. But so it must reveal the sex, and second, it must not violate the well-being of the child. So if it violates the well-being of the child, then the registration officer will reject the name. For instance, it is not possible to call in Germany to call your child devil. That they say devil is accepted as a second name in Germany, but not as a first name. So there are some people, even a chief minister in Germany has the name devil, Teufel, as second name, but it is not accepted as a first name. And here it is for the registration officer to consider whether the name which the parents propose is against the well-being of the child. And I give you one example of this. There was a woman in Germany who went to holidays in France, and she came back and was pregnant, and then she got a child and named that child Souvenir. And so the registration officer had to think about whether this was acceptable under the legal condition that it does not violate the well-being of the child. And he decided this was acceptable, right? Now the same lady, 1 year later, she went again to holiday in France, came back, was again pregnant, and then she called this child Souvenir 2, you know. And this time the registration officer did not accept it, you know. So if we compare these two legal rules, then the question is, which legal rule is better? Or under what condition is one rule better than the other rule? And what are the relative merits and the advantages and disadvantages of these two different rules? What would you say? The second rule has much more flexibility. It gives much more choice to the parents than the first, because the first is a closed list, right? So now assume that this closed list is not steadily updated. But, you know, the preferences of parents with regard to the names of their children, they vary, you know, they change. Or you might have immigration in a country, and like Indians are coming to Germany, and they don't want to call their child Fritz, let's say, or any other German name. They want to call it Sapkal or whatever, or an Indian name. And so then it has to be updated. And if the administrative system is not flexible enough, then you have an old, outdated list, and it does not meet anymore the preferences of the people, right? So that is the clear advantage of a standard. Okay. But what is the disadvantage of the standard? Would you say it is always good to have the second rule, or could there be some rationale for the first rule?
The second rule gives a kind of discretion to the decision maker.
To the civil servant. So, yes.
If he is not so much skillful, then it might ultimately harm the economy as a result.
Yes, I think this is a very important. What you say. You see, if we have this imprecise rule, you know, the parents can do what they want, but there are some limits, and the civil servant has to decide now whether they have kept the limits. Then you must have a civil servant who is first very loyal to the law. He must not be corrupt or disloyal to the law, right? And second, he must be knowledgeable also. He must be well trained. He must know what, what possibly, whether a name like Souvenir or Souvenir 2, what impact that might have on a child. So you cannot use an unskilled or semi-skilled person and entrust this person with taking such a decision, right? Now, if we look today, what the situation today, how it differs from the situation 250 years ago. Now, today, such a registration officer has at least not a university education, but a kind of higher education. So before becoming such an officer, he gets some training in psychology and so on. So he knows what he has some expert knowledge about this. And therefore, one can reasonably entrust him with such a decision. But 250 years back, that was different. Then 250 years back in Germany, perhaps 10% of the people could read and write. And many civil servants, they could just read but not write. So if you have a civil service in which the civil servants are not well trained, in which they have little expertise, then the first rule would make more sense, because what you can then give the position to a civil servant who can just read a list. No other qualification is necessary for that. So you can give that job to somebody who is not well trained, because what he has to do is just to take a mechanical decision on looking whether the name is in the list and then take the decision. Whereas when you delegate this power to the civil servant, you must be sure, or it is at least advisable that you must be sure that the civil servant, is well trained and loyal to the law. There's another reason. Sometimes a clear rule is preferable, but one does not have the information of sticking to a rule. Now, for instance, take the problem of legal age. How is the legal age in India? Somebody who is can fully conclude contracts and so on, we call this legal age. What is the legal age in India? 18 years. So this is a clear rule, right? That was not always the case. It is 18 also in Germany, in the whole of Europe. But in the Middle Ages, the rule or the norm for the legal age was not such a clear rule, but it said the rule was legal age, somebody has legal age when he is sexually ripe. So a woman had the legal age when she could get children, and a man the equivalent thing. And then when it came to a court proceedings and the judge was not sure whether the woman or the man had a legal age, then some expert, older women or older men, would then check the body of that person to see whether she or he was of legal age. Now, why was that so? Do you have any idea why they did not fix it at 18? Because at the time, nobody knew exactly how old people were, because we had no birth registers. The birth registers in Europe were introduced only starting from the middle of the 13th century, and only when the church introduced the birth registers and every newborn child with name was written in the birth register, one could verify how old a person was. Before that was not possible, and therefore a rule of 18 years was simply not possible. Again, you see what the relative, sometimes you cannot have a standard, you cannot have a rule, even though the rule is preferable, you have to have a standard. Now, one obvious thing when we look about the relative merits of rules and standards is that rules economize on the cost of applying the rule. So, for instance, if you have a rule, a traffic rule with a speed limit, let's say 50 or 30 miles per hour in the city, then for a policeman it is very, very easy to find out whether somebody has violated this rule or not. So the administration of the rule per case is, the cost of administering the rule is quite low. Or in more economic terms, we can say that the variable costs of applying the rule are low. But to make the system, efficient, to have it efficient, then the cost of generating the rule are very high. So, for instance, let me go back to this example with the list of the name of the children. So you have then, at the level of the state, the government has to give that task to a commission, which makes this list, assembles these lists, with dozens of experts and so on. They work for months and so on, and then they make this list. And they have to update the list every year, let's say, and so on. And if you don't do that, then you get, you get just end up in a mess. So the cost of the rule specification are very high for the rules. And however, applying the rules, applying the norm, the costs are very low. And therefore, you have here, you see, here we have the costs of the norm specification are high for rules, but the cost of applying it are high. Now, this is the number of cases. And here, for standards, the costs are low. You could, for instance, make a rule saying that everybody who drives a car has always to drive reasonably, which does not cost anything. It's almost zero, the cost. But for a policeman to find out whether that was still reasonable is very, very difficult. So we have here a trade-off between the fixed costs and the variable, between the fixed cost of the rules and the variable cost of the rules. The fixed costs of the rules are high, the variable costs are low, and for the standards, the fixed costs are low and the variable costs are high. Now, this leads already to one research result on this matter here. If you have legal problems which repeat very often, which are always the same problems, and you have a large number of cases, then it is advisable to have precise norms, precise rules. If, however, you have cases, or if you are in a field of the law in which you have few cases only, then it might not be economically defendable to incur such high costs of specification. You keep the cost of specification low, at the expense, however, that when the law is then applied to a particular person, then the costs are higher. And therefore, if you have large numbers of cases, rules are preferable. If you have low numbers of cases, standards are preferable. But this is not the only thing. The next thing is the question of qualification and of loyalty. Qualification and loyalty. Now let me first relate this idea of rules versus standards to qualification. We have around the world, we have the law of limited corporations, right? Of limited corporations, stock-listed companies. Now, what are the problems of this law? What does the law try to solve? Which problems does the law of the limited company try to solve? That is the problem which is well known in economics under the principal and agent theory. If people cooperate, then there is always space for opportunistic behavior. And in a company, you have the problem first. The first problem in a big company is that managers might exploit the company for their own purposes, right? So I give you just one example how that happens, not in a country like Russia where there is much corruption in the system, but in the United States. The manager of Walt Disney Company earned within 12 years $85 million. $85 million in terms of boni and so on in his own personal pocket, when at the same time the shareholders of Walt Disney Company earned less than if they had bought government bonds. You know, that is the exploitation of shareholders by managers. So that is one problem of the corporation, that the managers, especially of so-called widely held corporations, exploit the shareholders. This is one problem of corporation law, which corporation law should solve. The second is, this problem is often solved by having companies in which one shareholder, let's say a family, owns a block of shares, a majority or at least a large portion of the shares, and controls the whole company and can also control the management. So for instance, in developing countries, you have almost in all developing countries, you don't have widely held shares because the problem of controlling the managers cannot be solved. So you have large, wealthy families who hold the share, who own the shares, and they can monitor the managers. So they can solve this problem not by the law, but by direct control. Then you have solved one problem, but you have created another problem, that now the mighty guys in the company are not the managers anymore. They are controlled by the families who own the company, but the minority shareholders who hold 20, 30, 40% of the shares, and who have a diverse portfolio, pension funds and so on. And company law the rationale of company law is to solve these two problems. That first, managers should not exploit the company, and that the blockholders, what we call blockholders, should not exploit the small shareholders. How can these problems be solved? Now, there are two strategies. One is a rule-based strategy and one is a standard-based strategy. For instance, take the company law in the United States. In the United States, the company law is not a federal law, but a state law. So each state, New York, Virginia, California, and so on, has its own company law. But the company law, which almost all companies in the United States use, is that of Delaware. Now, the company of Delaware is a company law which imposes almost no restrictions on how to write the statute of a company. So, if I remember this correctly, the company law in Delaware only says that a company must, the norms which are mandatory rules, a company must be a legal person. That is necessary. A company must have a board. And a company must have a management. And all the rest of it, it's perhaps a bit exaggerated, but all the rest of it is left to the people who set up the statute of the company. And then it can be listed. Now you could say, well, but this is very dangerous because now you have the managers and the shareholders, the blockholders, and they can exploit everybody. Well, this is partly true, but partly it is not true because this opportunistic behavior is checked by Delaware courts. So if a manager schemes, or if he's not loyal to the company, then you can sue the manager, and a court in Delaware will look at it and see whether that managerial behavior is still covered by what they call is still covered by whether it is still loyal to the company or whether not. And otherwise, there are severe sanctions against the management or against the board members. Now, for this, they use the so-called business judgment rule. Now, for instance, assume the following case. There is a manager of a stock-listed company who is also the owner of another company. So he's the manager in company A, but he owns company B, different ways. You can say, this is a clear-cut rule, if a manager cannot buy goods from a company which he owns, which he himself owns, or is a blockholder of a company. That is clear-cut. Or you could say the manager cannot buy goods from company B, which he owns, if not the board, the whole board takes a decision that he can buy. So there must be a board decision about this. Then also that could solve the problem. Or you could have no such rule. The manager can buy, and that is the case in Delaware, where the manager can buy this, but if somebody thinks or believes that he's disloyal and that he, by way of this trick, has channeled the profits from the company which is entrusted to him to the company which he owns, then this violates the business judgment rule and the manager is brought to justice by the court. Now, if you have this very vague rule, very vague norms, like in Delaware, where the manager can do almost everything, then this has, of course, the advantage of flexibility, much more flexibility. It can be the right thing that the company buys from the manager, from the company of the manager. So if you have a strict rule prohibiting this, that might, in the majority of cases, be good for the company, but there might be cases in which it is bad for the company. So to check this, however, you have to have judges of corporation law who are very knowledgeable about what is going on in a company. You see? That is a similar problem as that with the registration officer and the name. So these people in Delaware, they have been managers themselves. They become judges in their 50s, you know, when they have a lot of experience with companies. And they are knowledgeable and they can take such decisions. And then you can have a company law which is based on standards rather than on rules. But now take as a counterexample the case of Russia after the collapse of communism. In Russia, the judges, well, now it might be different, but let's say 10 years ago, the judges had no idea how a capitalist company works. You know, they had got that training during the Soviet Union. They had only knowledge about how a command and control economy works. They had nothing, they knew nothing. And the reason, the consequence of that was, and this was the right thing to do, even though it did not work very well, in the 1990s, when Russia changed its or newly introduced corporation law, it said, well, we cannot have a company law like Delaware. We must have a company law which is very precise, which tries to wipe out this corruption within the company by very strict and very clear rules, which you can easily observe and which the judges can easily see and check whether the rule was violated. So, for instance, they had one rule according to which one member of the management board had to be elected by the shareholders with supermajority. Thus, this guaranteed that the management team, that there was one in the management team who had the trust of the minority shareholders. See, otherwise, if that was not done, then the registration officer would not, in the first place, would not even register the company in the company register. The company could not be established. See what I mean? That is very simple. Or another rule could be, I don't know whether that was so, that managers cannot buy goods from companies which they themselves own. In Germany, we have also such a rule. Also, the German corporation law is very much rule-based and not standard-based. So everything which is not explicitly allowed in company law in Germany is forbidden. Everything where the law does not say this is allowed is forbidden. So we have a very precise rules in company law, and However, what might be good for Russia might not be good for Germany, and what might be good for Germany might not be good for the United States or for India. So one of the leading company lawyers in the world is Rainer Kragman from Yale University. And he was once, I know him very well because he gave lectures in the institute of which I was the director and of the PhD program. And René Kragman, he drafted actually the Russian company law. He was for a couple of months in Moscow, and together with two other colleagues, they drafted the company law. And he said, well, in Russia, that it was the right thing to do to draft a company law with very clear rules, because the judges do not have the expertise. They must be given clear directives what to do, and the judges are also not loyal to the law in the same sense as in many other countries. They are sometimes corrupt, so you must give them clear and bright lines, and if they don't keep the lines, it is easy, you can easily detect it, then bring the justices to can control this. And he said that to his own surprise, the Duma, the Russian parliament, accepted this full-fledged, but it didn't work very well. But he then also said, you in Germany, you have the company law, which actually goes back to the 19th century, of a developing country. You have a company law which consists of so many rules, which is not good for an advanced country. Now in Germany, we got our company law in the 1800 and in the late 1870s. And the reason was this. Company law was totally unregulated until then. So there were almost no mandatory rules for company law. So if somebody, if a group of people started with a new company, they could write the statutes as they liked, the company contract, the statute of the company. And then we had a crisis in the 1870s in which more than 100 stock-listed companies went bankrupt. And then we discovered that all these companies went bankrupt, but that the blockholders, they did not lose money. Somehow they managed to preserve their money, whereas the small shareholders lost everything. That of course caused an outcry, political outcry, and this then led to a company law which was one of the strictest in the world. So everything what was not explicitly allowed was forbidden, to protect the shareholders, the small shareholders and financial investors against such corruption in the company. But since then it has changed a little bit more towards rules, more towards standards, but as Kragman said, not enough. He said, you are now so developed, Germany, 1870, Germany was still an agricultural country, but now it is a highly industrialized and modern country. And he said, you must change your company law much more in the direction of the Delaware company law. You see what I mean? So this is the rationale that if you have something, if you have a legal problem, like how to organize the corporations, then you have always the choice between organize it in a, let's say, lax way and delegating the decisions to the judiciary, saying, let's say, like Delaware, we don't make too many restrictions, but if somebody does not comply with his duties, the manager's duties, then he is brought to justice. But you need for this a very knowledgeable, well-trained judiciary, and a judiciary whom you can trust. But if you have a judiciary which you cannot trust, then it is better, and which is not well-trained, then it is better to have rules, even though the rules have some other disadvantages. See what I mean? Sometimes, however, the rules are also used, rules by Parliament, to check and control politicians. Now, I give you an example. I know that eminent domain power and taking of land from farmers, for instance, for firms, is a big issue in India, right? Now, one of the problems in India is when the government or a municipality or a state government takes land from farmers and gives the land, let's say, to companies for purpose of residential purposes or to make industrial sites and so on. That is somehow necessary, or to build roads, or to build public utilities like electricity, or to build roads and railway lines. Then you have also, Parliament has the choice of choosing a rule or rules and standards. Now, if Parliament trusts the government, then it can simply make can simply draft a law, a taking law of eminent domain law, saying that under these and these conditions, government can take the land from farmers when it is necessary for economic development. Right? But economic development is something very vague, can mean almost anything. Would you agree? So therefore, many countries where they do not trust the politicians, they have even constitutional rules which say that the rationale for the conditions of taking must be precise. This is the case in Germany, for instance. So if the government takes land for energy safety, this is legal. If it takes land for road construction, this is also legal. If it takes land for economic development, this is illegal because it is too vague. This is illegal for vagueness. See what I mean? So I think that the present problems which you have in India are partly result from the fact that the government branches could be better controlled by laws which are more precise. So if the law is then more precise for instance, if it has a list, let's say, for the reasons for which the land can be taken, and if the land is taken for other reasons, then the taking is illegal. Then you give government branches and agencies less discretion just to take the land whenever they want it and for reasons whichever they please. You see, that is also a question which pertains to the rules and standards. So let me sum this up. Rules have higher cost of specification and lower cost of administration. Standards have lower cost of specification but higher cost of administration. Rules are good if you do not want to delegate too much. If you cannot delegate, either because those who take the decisions are not well trained, or because those who take the decisions are not loyal. If, however, those who take the decisions are well trained and loyal, you can delegate, and then you can take the rules. Okay? So this is, now I come to the next. Yes, yes.
So does the same justification also stands for criminal law? I mean, if the judiciary is not so skillful in a country, then should that country have a more precise criminal law? Because in common law, we believe in the principle that let 10 criminals escape from the clutches of law, but one innocent should not be punished. So, sir, having a very precise criminal law will lead to punishing innocent people.
No, I think I'm not sure whether this you can relate this to this question, because this is not, this principle that you have a very high standard of proof in criminal law cases, and you better, when you have doubts, you better let a criminal go rather than to punish an innocent. That is not a question of substantial law. In criminal law, you always have very precise norms. You know exactly what a theft is, or what a robbery is, or what a sexual assault is. That is all must be very clear in criminal law. But the problem which you address here is not the substantive law. So in the sense that if you do something, you do not know whether this is legal or whether it is a crime. That can also be a problem, but usually you know what you do, whether it's a crime or is not a crime, right? The problem which you address is the standard of proof, how much you prove. And in criminal law, unlike in, for instance, civil law or in tort law or in contract law, the standard of proof must be beyond reasonable doubt. And that is a general rule worldwide. You have it in India, in Germany, and everywhere. And that has nothing to do with rules or standards. A criminal law which, the problem which you address would be a problem if somebody does something and he looks in the law and he says, I don't know, is this a crime or is it legal? See what I mean? But that occurs also in criminal law, but very seldom. Usually, criminal law is modeled along our convictions of what is right and wrong. And therefore, people know whether what they do is right or wrong. even though there are some cases which are not so easy to but that has nothing to do with this standard of proof, the beyond reasonable doubt.
In India, there is a lot of issue regarding purchase of land by the government.
Yeah.
And this is happening probably after the millennium, in the millennium years. Earlier, there was no such issue. I mean, you can get the land for security reasons, for agricultural purposes,
Uh-huh.
for building schools.
Yeah,
building-
yeah.
But now there is this issue. I don't know what maybe the reason behind this, but is it the price, imprecise reason for?
Yeah, well, as far as my knowledge goes, but you might be much more knowledgeable about this, there was a change of this law, of taking law, in 2013. And they introduced a rule by which the taking can only take place if 80% of the affected agree to this. And this is, of course, gives them a very strong position. And I think that the present government wants to abolish this, but doesn't get the support of it in the upper house. So that is one of the problems, I think. Okay.